Well, good afternoon. My name is Sawnie McEntire, and I am from Texas, and my topic is effective opening statements, how to plan, prepare, and deliver an effective opening statement. I want to start, however, with a disclaimer. I know many of the trial lawyers in this room, and I know that many of these trial lawyers have extremely high skill sets, and it's not my purpose here to suggest how they should do their opening statements. My purpose is a little bit different. My purpose is to talk about the elements of what you need to get to the point where you start making your opening statement. What you need to do, from my perspective, from day one. From my perspective, saying what Jerry just echoed, is you can win or lose your case, and frequently cases are won and lost at the opening statement stage, because that is a time to captivate the jury's attention. That's the time to get the jury invested in the facts and the profile of your client and your case. And so it's really not an opening statement at all. It's your first final argument. And that's how I think we should all, how does this work here? Here we go. How we should all perceive the importance of this role. Earlier today, I sat in on a presentation about the Reptile Strategy. And the Reptile Strategy is alive and well, and it's been actually being pursued for many, many years. It just got a name in 2009. And the Reptile Strategy really does prey upon the fears and the instincts of jurors who are bewildered by the facts that they're seeing. It is calculated by the plaintiff's lawyers from day one to inspire anxiety, an instinct for survival, anxiety and fear. And by the end of the case, the plaintiff's lawyer's goal is to translate that anxiety or that fear into anger, and anger at your corporate client. An opening statement is a rare opportunity. It's one of only 3 opportunities that we as trial lawyers have to actually engage with the jury. In most venues, both state and federal, lawyers will have the opportunity to participate in jury selection. That's an excellent opportunity, a very important opportunity. Opening statements is your next opportunity. And then, of course, your final argument. Your average jury attention span is not substantial. So you don't go in and be boring. You don't go in and just recite what you think the facts of the evidence might be. You need to have sound bites. You need to have something to captivate the jury, to pull the jury in. You need a hook. And the hook is your client and your facts that you've been working with and developing from day one to be in a position to go in and tell an interesting story from moment one. That's the key. Will Rogers said, "You will never get a second chance to make a first impression." It's a little trite, but how fundamentally true is it? Because when you stand up in front of the 12 jurors or the 6 jurors, as the case may be, they're scared. They're interested. They're not sure. They're in an alien environment. And this is your opportunity to calm them, to talk to them, not lecture them, but present to them something that makes them interested in you and your client and your case. And that's the key to an effective opening statement, in my opinion. Shakespeare said it well in Henry VI. The first thing we do is we kill all the lawyers. How many times have the trial lawyers been in the courtroom and the jury panel is filing in and they all kind of looking around like, I've never been here before? And that's true. A lot of these jurors, this is a totally alien environment. They see a bunch of lawyers in pinstripe suits and the judge in his robes and files on the desks, and they don't know what to think. Some are going to be scared. Some are going to be anxious. How do I fit into this process? How long am I going to be here? All those types of things are going through their minds. And some of them may actually not like us because of other things beyond our control. So an opening statement has to once again establish a rapport and a relationship with these jurors to make the jurors like you as the trial lawyer, because if they like you as a trial lawyer, you've got a better chance that they're going to like your client. I believe that trials are wars, certainly really big battles. So you need rules of engagement and your sound bites, your battle plan, your blueprints for how you're going to wage this battle are your trial themes. And the trial themes don't start the night before you prepare and give your opening statement. Your trial themes start on day one. And I'm going to talk about why that's so important, because a trial, the trial preparation stage is an evolutionary process. You begin with facts, bad facts, good facts. You neutralize the bad, hopefully. You try to enhance or augment the good. And you're constantly refining and refining your facts and developing your sound bites. So when the bell rings on opening day for an opening statement, you're ready to go. And this takes time. When jurors come into the courtroom, they're going to fall into one of four boxes. This is like a game of marbles, in my opinion, okay? You are probably going to have a few marbles in the strong defense box. Depending upon the venue, you may have a lot of marbles in the strong plaintiff's box. These are the pre-orientations, the biases, the sense of what's coming. When these jurors come in, these are their attitudes. After the plaintiff gives his opening statement, assuming he's good and effective or she's good and effective, there's going to be some shifting. Some of those strong defense jurors may be a little less strong, and they say, well, he's raised some interesting questions. I still want to side with the defendant. I haven't heard the evidence yet, but he's really raised some good points. Some of those weak defense jurors may actually start saying, I'm going to listen to this plaintiff's case. There's something going on here. And then some of the weak plaintiff's jurors are going to get galvanized, and they're going to go into the strong plaintiff box. So if too many strong plaintiff's jurors end up in that box after their opening statement, the defendant is a tremendous disadvantage. And so what the burden we have as defense lawyers is to reverse this trend. We need to reverse it and get more marbles into our strong defense box. One way to do that is also find your leaders. Who are the forepersons? Who do you think are going to be your foreman or your foreperson? And start working with them aggressively. So how do we do this? We do this through pathos, logos, and ethos. Pathos, the emotion of the case. What is the emotional hook? Logos, the glue, the logic of the case. What happened? Or, equally important, what didn't happen? Ethos, the credibility and the trust of your client. These are the cornerstones of effective advocacy. And this is not something that was born in some law school. This is something that was born and birthed 2,500 years ago with Aristotle. These are the three tenets of effective advocacy, and they're equally true today. In fact, the Reptile Strategy exploits them. Let's start with logos and logic, the glue, the facts, the data, your storyline. A lot of jurors don't care. A lot of jurors will instinctively go directly to credibility and emotion, and the plaintiff's lawyers know this. And that's why they prey on those emotions, those negative emotions, those fears, and they go right to emotion and credibility. So, as members of the defense bar, I'm not suggesting that the facts of the case aren't important. They're very critically important, but we need to be mindful and sensitive to the fact that we have to counter what the plaintiff's lawyers are doing in opening statement, and that doesn't happen the week before you start that trial starts, you put pen to paper. This is from the very beginning, as the counsel who talked about it this morning with the Reptile Strategy, it starts with the pleading stage. It starts with how you prepare your witnesses and how you present them for deposition. Looking for the buzzwords, kill, greed, avarice, putting people over, profits over people, those types of things. So, Aristotle says character may almost be called the most effective means of persuasion. If a jury likes you and they like your client, chances are you've got a really significant edge. If the jury doesn't like you or doesn't like your client, you are at a substantial disadvantage. And that's why the plaintiff's lawyers want to attack your client and show that they're greedy, avarice, sinister, they kill people. So, when I talk about credibility, I'm not talking about just the credibility within the context of the facts in the case. I'm talking about something larger, something more macro. I'm talking about, is your client ethical? Okay, sure they are. So let's portray them that way. And let's develop evidence during the course of the case to portray them that way. Moral, principle, a good corporate social citizen. Develop the evidence where you can present this effectively in opening statement on day one. Logos, the glue, simplicity, simplicity, simplicity. The more simple you have your trial themes, the better off you are. Repeat, 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 because you're effectively providing one or two or perhaps three defense jurors with the ammunition they need to go back into the jury room at the conclusion of the case and advocate for you. So you want to make sure they understand, those 2 or 3, maybe 4 defense jurors, that they really grasp and understand what you're discussing. Pathos, the emotion of the case. Every action must be due to one or other of 7 causes: chance, nature, compulsion, habit, reasoning, anger, or appetite. That's a quote from 2,500 years ago. So let's talk about it in the context of today. Defense lawyers sometimes spend too much time on the reasoning. Logical, that's what we're hired to do, present the facts well. Plaintiffs' lawyers go to anger and appetite, and they start focusing on the negative things, making, again, the jurors dislike your client. Planning is bringing the future into the present so that you can do something about it now. I think this is a great quote. Planning is bringing the future into the present so that you can do something about it now. So you ask yourself on day one, where do I want to be in a year and a half when the bell rings and the jury's in the box? What do I need to do now and over the next several months and year to get to the position where I can truly control what happens on day one? And this chart is intended to show that, because as you get closer and closer and closer to trial, it's like a chute, like in a rodeo. They got the guy on the bull that's about to go out into the rodeo ring. He gets into the chute. Your options narrow. By the time you get into the chute, the week, the month, the 30 days before trial, the options have substantially narrowed. Your ability to control the facts is basically over. So you have to work on your facts and the key facts and neutralize the bad facts months in advance and refine them and expand upon them and augment the good and neutralize the bad. Because by the time you get into the chute, you want to know you have put your very best foot forward, and your best foot forward can only be achieved, can only be achieved if you've been working on placing the foot forward for the last several months, if not years. So that's where your trial plan comes in. And this is true, we tell our young lawyers at our firm, this is true of a simple case or a complex case, all the way, the entire spectrum. Where you want to be, how are you going to get there, what are your goals, what are the key themes, identify the good facts, identify the bad facts, equally important if not critically important, and figure out how to neutralize them. Next steps, and this is so important, I believe, for trial lawyers. Every deposition in my book is a trial deposition. There's no real thing known as a discovery deposition. Every deposition you take is an opportunity, a significant, rare opportunity to identify the good, augment the good, and neutralize the bad. And every opportunity should be taken advantage of. If you're not, you're missing a chance to advance the case. Then you get to the final steps. You're in the chute, you're preparing your opening statement. Now you're playing with just the nuances of the words, the concepts. You're selecting your exhibits you're going to use to convey the themes that you've already identified and had in place for months. And that's how you drive your message home. So it's a stepping stone process. It's a stepping stone process with each step very critically important. Start with the initial interviews, first document reviews. You move into the deposition stages. You use the depositions as tools to get where you need to be on opening statement. And then you narrow and refine your trial themes into simple trial themes. I like to talk about a few examples and tie them into Aristotle's terms. The top case was a case that I tried last November, 2-jury verdict. I actually represented the plaintiff. It was a declaratory judgment action, and we were seeking to have some wrongful liens that were wrongfully asserted as security interests vacated. We started the lawsuit, and they filed a massive counterclaim. During opening statement, we came up with the idea that the wrongful liens were like a financial stranglehold on my client's financial neck. Couldn't borrow money, couldn't expand, couldn't grow. So we came up with the concept of a chain with this red link. And I used this twice in opening statement and also used it with some expert witnesses. And at the conclusion of the case and final argument, I showed this slide again. And then I had the computer technician with all his devices explode the red link and it just vaporizing it, and the chain came loose. And I said, this is what we're asking you to do after 4 years of wrongful liens. Jury understood. So we had simplified the trial thing. We took a complex UCC1 issue and we reduced it to something plain and simple as a chokehold. Logos. I had the privilege of representing a well-known real estate broker in Texas, commercial real estate broker, who was sued over the loss of a really big deal. And it was evident to me that there was nothing that he did wrong or failed to do. The problem was, and the diminution of property values, was the Lehman Brothers and the entire economic fiasco that we all experienced. And so we repeated that theme with every witness. I even used it with the plaintiffs. You heard about the 2008 crash. You knew that this was having impacts, and the admissions would come in inevitably. That became a building block. It was a simple, logical thing that we used to communicate to the jury, and that was a defense verdict. This is another case, E. Every one of you see Enron, the name Enron and the crooked E, you have a reaction right now. You think of perhaps corporate greed, C-suite greed, avarice. Well, I had a case where I was actually involved with a friend of Enron, which is a special corporate creature. It's not actually on the balance sheet. It's not identified as a subsidiary. But there are individuals who somehow, for some reason, have an allegiance to Enron. And so it's a way of having off-balance sheet assets. And so the name Enron was repeated frequently with all the experts, all the fact witnesses, and then ultimately with the fact finder. Now, this is actually an example of a reptilian strategy, because we're appealing to something in the fact finder's mind. Hey, you should be scared here. There's a concern here. The next case, I represented 17 homeowners who were all airplane pilots, and they lived, their homes were on a landing strip, and instead of having cars in their garages, they had little airplanes that they flew. And so they would, some of them actually flew to work every day and flew home back from work every day. Unfortunately, they didn't own the landing strip itself. A commercial investor, a real estate investor, owned the landing strip. And he said, well, it's time. Property values are going up. I'm going to get rid of them, and I'm going to develop the landing strip. So we had this concept of an easement, an ingress-egress easement. So that's difficult also to communicate to a jury. Very legally intense type concept. So we came up with the analogy, a simple trial theme. It's like your driveway. So these people, you would be very angry if someone prevented you from driving your car into your garage using your driveway. And that's all this was. This landing strip was nothing but a driveway. It was a driveway actually to their homes, because the hangars were literally attached to their homes. We got a verdict in that case, a positive verdict. This is another case, Logic and Logos. This was unfortunately, it was a tragic rollover case with an ejection. The wife was driving the vehicle, the husband was in the back seat, and he died at the scene. The big issue was he or was he not wearing a seatbelt? Well, we said he was not wearing a seatbelt. There are no load marks or web marks showing the stretch on the seatbelt. They said, oh yes, there are. Look at that right there, that little speck. That means he was wearing a seatbelt. That's a horse race. And you're going to lose some jurors there because it's highly technical, and I don't think jurors really like a lot of technical evidence. And so this was actually a gift to us. They identified the local Baptist minister as a fact witness on grieving. And I took his deposition, and they didn't object while I asked the questions. And he said during the grieving process, the widow had confided that she believed her husband had not been wearing a seatbelt, that was actually asleep across the back seat. Well, the objection was waived, if there was one. It came into evidence, and that was an instant defense verdict, because the local Baptist minister, how credible do you get in that? Okay, end of story. Tragic case, defense verdict. This is another example of the reptilian strategy. My firm represented a pharmaceutical company in a series of pharmaceutical liability cases in Texas. We tried 4. We had 2 defense verdicts. There was 1 plaintiff's verdict. There was a mistrial. Without exception, the plaintiff's bar, and there were some well-known plaintiff's lawyers, went out of their way to talk about the company that sells and markets the killer drug. Death, kill. I heard it 5 times in opening statement. And so they're appealing to corporate avarice, greed, putting dangerous medications into the marketplace, and so it's incumbent upon us to have evidence to talk about all the good things that this company did. And this company made some very important products that saved people's lives, like penicillin. Some person in this room could take a penicillin shot and fall over dead with an anaphylactic reaction, but if you didn't have penicillin, think of all the many millions of people who might die. So we focused on the good to rebut the bad, but we just couldn't come up with that overnight. We worked on it and developed it with our experts over a long period of time, so we were ready to use this. And we did get 2 defense verdicts out of the process. So that's, my time is up. That is my presentation. I leave you with this. Every trial lawyer in this room will have a little bit different spin on how he or she prepares their opening statements, but I think we would all agree it is a critical opportunity to put your very best foot forward. And frankly, I think it's very important to recognize that it's really not a boring overview of what the evidence might show. It is a first final argument. Thank you.